which are approved by Bar Council of India and management courses by All India Council for Technical Education AICTE, Ministry of HRD and Government of India. The institute is accredited as Category A by NAC and assessed as Category A+ by State Fee Regulatory Committee, a fee committee of Government of and City of Delhi, and has rated highest grading A by Joint Inspection Committee of Government of and City of Delhi and Guru Gobind Singh Intertrust University. The institute has been rated Grade A by Academic Audit Cell of Guru Gobind Singh Intertrust University consecutively for past 6 years. Gibbs has also been rated number 2 by Times B School Survey 2019 and 21. The topic for today's workshop is competition advocacy, and for today's program, we are honored to have with us as resource person Advocate Mr. Avinash Sharma. Sir, first of all, I would thank you for sparing your precious time for us today.
Thank you.
Thank you very much, sir. Enrolled as an advocate with the Bar Council of Delhi and specializing in competition, litigation, and arbitration, Mr. Avinash Sharma presently acts as an advocate on record at Supreme Court of India. Sir is also the counsel for Panel of Competition Commission of India, Municipal Corporation of Delhi North's AOR at the Supreme Court of India, International Center for Alternate Dispute Resolution Panel's mediator since July 2015, and Central University of Haryana's AOR at the Supreme Court of India since February 2018. Sir has also acted as Delhi High Court appointed local commissioner in various lawsuits related to the property and intellectual property matters. Sir has obtained his first law degree from Intertrust University, New Delhi, and subsequently remained involved with various academic and professional studies in divergent fields of law. Sir has bagged the All India runner-up and All India champion trophy in two national level law quiz competitions and winner of an international moot court competition. He has spoken at the National University of Singapore, International Institute of Social Studies at the Netherlands, University of International Business and Economics in China, Athens University of Economics and Business, Greece, and other international forums across the globe. Sir, I, on behalf of Center for Legal Studies, Gibbs, heartily welcome you to this program. We are honored to have you, sir. Now, I would like to request to take you to take the program forward, and the virtual stage is all yours.
Thank you. Thank you very much for the kind words. And I'm indeed an honor to be at the law school which is related to Intertrust University. And I was fortunate enough to be from the first batch from the university own department, University School of Law. When the university started way back in 2001, so I was from the first batch from 2001 to 2006. So, and at that time there was just two private colleges, MIT and Vivekananda Law School. And now I have been told we are having a more than 12 or 13 different law schools in the different part of the city and in the NCR. So thank you very much, the organizers. The topic for today is competition advocacy. So you need to first ask, we should ask ourselves, what exactly is this competition advocacy? Any comment by anybody, feel free to interrupt me whenever you have any query, any question or anything. So what I am going to do is, first I'm going to speak few things about competition advocacy, and then I'm going to talk about competition law as such. And then, of course, I intend to take a couple of questions which you may have about this topic or this subject or this particular field of law. So feel free to interrupt me whenever you are in doubt. So competition advocacy, the way we understand the advocacy as a lawyer or as a judge or as an academician, those who are doing something, dissemination of knowledge or teaching or research or just try to provide some kind of advocacy. So when lawyers are arguing in court, we say advocates are doing the advocacy. Once some NGO is trying to promote or they try to say something about XYZ, we also call them advocates for XYZ, say, subject. When we are talking about the competition advocacy, it's not a general subject. competition advocacy is actually a branch of, say, competition law and policy. And this is very innovative in a sense. Whenever we speak about a law, so we always try to figure out there is some kind of enforcement, there is some kind of binding nature, there is some kind of obligation to do or not to do certain things. So when we are talking about competition advocacy, first thing which is coming into our mind is what exactly competition law is all about, because competition advocacy is just one of the small components about this entire subject. Anybody is having any idea about this subject, competition law? Have you studied this subject at any point of time, or you have come across this subject, antitrust law or competition law? Okay, let me just give you a very small example how this law is coming into the picture. I can see there are around 48 participants in this discussion, and let's assume we all 48 are, say, manufacturer or something of a particular product. Supposing we are producing, say, pen. We all 48 are producing a pen, and our customer is, let's say, this entire Gitaradan business school is our market. So we all 48 producer of this particular stuff is trying to have a patronage of all the customers within this school or college. So one idea is, I am selling my product, you are also selling your product. We all competitors are doing their best to have a patronage. What we are trying to achieve? We want to sell our product, we want to give our services, and we should maximize profit. After all, we are in business in order to maximize the profit, for sure. We are not here to make any loss making. So first you need to understand the market. So in a market, we have a 48 different manufacturer, and you may have a, say, few hundred, say, students or participants who are our consumer. So how we can capture the market? Market can be controlled or captured or dominated through few ways. Either my pen is superior to yours, you will try to make sure your pen is superior to mine. Third person will try to ensure that he is producing the same pen at the cheapest rate, because at the end of the day, what we are trying to achieve is we are going to sell our product at the most competitive price. So this is an ideal situation in a very, very competitive market in which everybody is trying to have a patronage of, say, your consumer. Now, we are 48 people. So there is a cutthroat competition in this manufacturing and the selling of this pen. So what we can do is we can sit on a platform like this particular virtual meeting, and we can say, instead of having this competition in the market, let's all collude. Let's all fix the prices. Let's all hereby decide that from tomorrow onwards, we are going to sell this particular pen at ₹100. Because we are aware that if we are fixing the prices, there will be complete foreclosure of the competition. There won't be any price war between me and you. So let's coordinate the prices. So the competition law, the first idea is you prevent any stuff, any agreement, any understanding, any tacit understanding between the parties whereby you try to control certain things. And what you are trying to control? You can say we are fixing the price, or you can say we are allocating the market. So in the North India, I'm going to sell it. In South India, you should sell it. Third person should sell in the East India. You should not enter into my territory. I'm not going to enter into your territory. So you allocate the market. Or what you can do is, whenever there is a tender in the North India, you should do all those, you should bid for that tender. I'm not entering into your area. So basically you allocate the market, or you indulge into, say, bid rigging. So if there are 48 different participants, so we try to collude, we try to coordinate the price, and we try to sabotage the entire process of competition. So that is the one problem. So this, what we call it, coordinated behavior of different entity to capture the market. So this is the ideal situation in which you have a different competitor. You could have a second situation in which we don't have these 48 players. We just have a one, or we just have a two. And that player who is having a, say, market share of, say, 90% or 80% or the 70%, there is no competition in the market, and there is just one big player which you can say dominant player, or you can say that person is a monopolistic or who has captured the entire market. So that person is going to have two kind of situation. He will try to ensure that he's already have the entire market. So he will try to ensure that there should not be competition in the market. And how he's going to ensure that? There could be two scenarios. First, he is going to reduce his prices, right? So let's take a telecom situation. That let's assume you have a one telecom player who is having a say market share of say 80% or the 90%. So second competitor entering into the market. So what this dominant entity will do, dominant entity is going to reduce its prices, right? And when we say reduce the prices in competition, or what you say below the average variable cost. So for example, the manufacturing cost of this pen is rupees say 10. So you say, I don't want any competition in the market. So instead of selling my pen at rupees 10, I'm going to drastically reduce my price. And the price would be even below the manufacturing cost. So you are making losses in first few weeks or few months or say few years, so that no competitor is going to enter into the market. And once there is no competitor in the market, so then you increase your prices, and then you try to charge exorbitant price from your consumer. So the first would be you try to exclude small player from the market, what we call exclusionary practice. And then when you don't have any competition, then what you do is you try to increase your prices, what we call as exploitative abuse. So that will be abuse of dominance. Actually, one entity who is controlling the market and try to put forth his own terms and condition on the market. So the competition law started way back in 1894, 95. So it's more than now 125 years old. It started in the US. The first country which was having an antitrust law was Canada. In India, we started this competition law in 1969. It was MRTP Act, the old act. And if you look at the modern competition law, which we have, is the Competition Act 2002. So our act actually is having a two mandate. One is enforcement, and second is not enforcement, but competition advocacy. So that's very unique. I'm just going to explain. I was just giving you the background, what exactly we are trying to do under this act. So as I told you, one idea is to prevent this coordinated behavior of different producer to capture the market. So that we called anti-competitive agreement, or say coordinated behavior. Second would be controlling the market if you are a dominant. So that would be abuse of dominance, abuse of dominant position. So that would be unilateral behavior. So in terms of enforcement, any competition regulator, be it a FTC or DOJ in the US, or the European Commission or the Indian Competition Commission, you will find there are provision which is prohibiting these kind of anti-competitive stuff. So they will have a provision for against cartel. They will have provision against bid rigging. There is going to be a provision for abuse of dominance under the act. Then you will realize that, okay, if the commission is saying that producer A and the producer B must compete and they must be very competitive in the market. So instead, and then there is a provision that you can't coordinate your prices. So what's about merging? Supposing there are four companies, A, B, C, D. So let's all merge together, or instead of having four competitors in the market, let's have a three competitor or two competitor or one competitor. So that is also possibility. And that's just imagine a situation, all these merger, acquisition, amalgamation, all these are legitimate business activity in the industry. So if you say you cannot communicate with your competitor, you cannot coordinate the prices. So instead of having a two entity, let's merge. So A is merging with B, or A is acquiring certain stake in company B. B is doing some kind of coordination with the C. So the idea is all those merger acquisition activity should go ahead. There should not be a problem. But any of these merger acquisition or amalgamation activity which is going to restrict the competition, which is going to reduce the competition, that is something needs to be scrutinized by the competition regulator. So for example, when we talk about that, say Reliance Fresh is acquiring Future Group, right? Reliance is also having a supermarket stores. Future Group is also having all these, say, Big Bazaar, Pados Ki Dukaan, and you have this food hall and all those supermarkets. So one entity is acquiring something in competitor. So you need to take permission from the commission. And out of say 100 merger, in 95 of those cases doesn't actually raise a competition concern. I can just give you an example. Supposing Tata Tea as a company is acquiring or say buying certain stuff say in Infosys. So one is in the tea, another is in say IT industry. On the face of it, you won't find there is any competition concern. But just try to imagine a situation. Let's say tomorrow Coke and Pepsi is merging. Just a hypothetical situation. So if the Coke and Pepsi, if they merge, collectively they both is going to capture the market more than 95%. Because all these brands, right, or say whatever XYZ cold drink which we have is owned either by the Coke or Pepsi. So the idea is if two competitors should not merge, so there should be some kind of regulatory mechanism who can control this kind of say combination, because Act is using the term combination, and the combination means it could be merger, it could be amalgamation, it could be acquisition, it could be say reverse merger, it could be even joint venture, right? So any idea in which two different competitors are joining hand, it's something which needs to be scrutinized, which needs to be kind of, there should be a kind of proper inquiry by the competition regulator. And the mantra for these competition regulator, especially in India, is that combination is not going to have a something called AAEC, which means appreciable adverse effect on competition. Just mark my words, appreciable adverse effect on competition. This is the term which you are going to find under the Competition Act, or you read any judgment on competition law, you are going to find it. So the idea is any cartel, any agreement, any abuse of dominance, any merger which is going to have a adverse effect on competition, that is something which needs to be prohibited by the commission. So that's the job of the competition regulator worldwide. So what I was saying so far was in the realm of enforcement, meaning thereby you have a set of rules, you have a set of regulation, you have a set of provision, you have an institution by the name say Competition Commission of India, you have an Office of Director General which is doing the investigation. So all these are in terms of enforcement. So what that's precisely is the law. What we are talking about today is the competition advocacy. Advocacy is a very unique feature in the competition law. What it tried to say, it say whenever there is a violation of the Competition Act, of course, there is going to be investigation by the Competition Commission, the DG office, then the commission is going to impose XYZ fine or something. Competition advocacy is basically, if you anybody is asking what exactly this term is all about, it is basically dissemination of competition law. So what exactly you do, you tell the government or any department or any PSU whenever they are framing any XYZ regulation. For example, I can give you a very small example. Let's assume a situation that university, GGS Indraprastha University is wanted to have say 100 computers, let's assume. So they have floated a tender. Now you can have a two situation. Either university can buy from one vendor, or university may float a tender in which they say that we are in requirement of say 100 computers. and you are asking quotation from say 100 different vendors, right? So if you have a competitive process, who is going to provide you the goods or services at the most competitive rate, you always try to buy your stuff from that particular institution or from that particular manufacturer. So in the competition advocacy, if you look at the provision which we have under the Competition Act, there is a provision section 49 of the Competition Act in which they talks about this term competition advocacy. And how it works, let me just explain in brief. Competition Commission is a market regulator. It is supposed to be an expert body on the area of competition law. So section which is doing the enforcement of all these provisions which I just told you, the anti-competitive prohibition of anti-competitive agreement or abuse of dominance or the merger control. Under section 49, the commission has been given a mandate. Now the mandate is twofold. One is whenever central government or the state government is coming out with any new law or any new regulation which is having some relation with the competition. Let's take a situation that central government is floating XYZ tender for their whatever policy you want to call it. Say it could be a procurement, it could be a tender, it could be a say pharma policy, or it could be the industrial policy or something. So whenever central government or the state government feels that they are coming out with any law which may have some bearing on competition, so they may, the word which has been used is may, they may make a reference to the CCI that we are coming out with something. You as a competition regulator, you as an expert in the field of competition law, you just please examine this particular issue, right? For example, what would be the scenario, say post disinvestment of say Air India? Let's just take a hypothetical situation. It has already happened and the commission has approved it. CCI has approved it, but any law, any policy which is going to have any bearing on competition law, so the central government or the state government may, mark the word, may refer the matter to commission, to CCI, to get their input from competition law perspective. So it's a discretionary on the part of the central government and the state government. They are under no obligation because the term uses may. Now, once that reference is coming to CCI, the CCI is supposed to examine this particular law from competition law perspective. That what is going to be the situation in the market, what is the nature of competitiveness in the market, what would be the effect of that particular policy or regulation. Let's take a situation tomorrow, central government is coming out with a policy that in multi-brand retail, you can have FDI. So far it is not. But in future, if the central government thinks that we should also allow foreign entity to operate in India in the retail sector. So you may have a Walmart, right? You may have even Amazon or the Flipkart in offline. So far they are in the online mode, they are not in the offline mode. So the government think that we should allow retail FDI in the retail industry. So they can also have a Kirana shop or something, which we have domestically. So what is going to be the effect of this particular investment in India? So whether those domestic Kirana shops, those domestic industry is going to be kind of wiped out by these foreign giants, that would be the one, or what would be the effect of these companies entering into India, and what would be the potential harm which is going to be on, say, the domestic industry. So the central government, before coming out with this new law or some amendment, they may seek a reference to the CCI, and the CCI job is to examine that issue purely from competition law perspective. They are not the, say, expert in XYZ, national interest or public interest or something, but they can examine from competition law perspective. So once some reference is coming to the CCI, it is job of the commission to examine that issue and revert back to that central government or the state government or the ministry within 60 days. So the job of the CCI is mandatory in nature, that they need to assess that particular thing and send that report back to the ministry or state government or the central government, giving its own input, that what is going to be the potential, say, harm on competition. For example, you have these three farms laws. So when, say, central government feel whether these farms law are good for farmers or not good for the farmers, and whether it's going to have a, say, more competitiveness in the agriculture industry or something, so they may send it to us. CCI doesn't have any suo motu power to make any comment on these laws or regulation or something. But if the matter is referred to the CCI, then the CCI is under an obligation to examine it and give its own opinion, finding, recommendation back to the concerned ministry or something. So this is exactly the competition advocacy is. What CCI is telling in that particular issue is not mandatory on that central government or the state government. So just mark my words. That's why we call it competition advocacy. It is something which is you are trying to persuade different ministry or the government, right? Let's take a simple example. Let's take your institute is trying to have a, say, buy, say, 50 computers, and in the tender process they say we want to have a, say, 50 computers and only Apple can participate in the tender. Let's assume, because we just want to have Apple computer and we don't want to have a Samsung or, say, Lenovo or say HP or something. So the very nature of this tendering process would be anti-competitive because you are foreclosing the market for other vendors, right? Other vendor won't be in a position to, say, sell that product to your institution. So when these kind of things, these kind of regulation are coming framed by any institution, so job of the CCI become important, because your term, your policy, your regulation is some kind of restrictive in nature. So under section 49, the job of the commission is actually to tell you what you need to do to make your process more competitive in nature, right? You may agree with that recommendation, you may not agree with that recommendation. That's exactly your headache, because the recommendation of the commission, when they are giving certain opinion or certain advisory under section 49 of the Competition Act, it's a pure advice. It's not binding on that central government or the state government. And if the center or the state government wants to implement it, if they are more interested in having more competitiveness in the market, so they may adopt it. If they don't want to adopt it, CCI cannot say that you must adopt it because this is going to be a kind of, so there is no binding in nature. So that was the one aspect of this competition advocacy. Second is dissemination of this law, which can be done through lectures, it can be done through seminars, it can be done through workshops, it could be done through publication of certain literature, it can be done in so many different ways. I can just give you an example. Prior to 2002, right, you don't have a provision against cartel. So there is a entity A, B, C, D. These four entities are colluding. They are discussing the prices that in XYZ tender, I am going to quote 100 rupee, you should quote 101, third should quote 102, somebody else should going to quote 105. So you all five are doing the information exchange. You all are competitor. So your prices are supposed to be competitive. Your decision should not be influenced by what your competitor is doing. So you should not do the information exchange. But then in this industry, if you look at the most of the cartel cases, these entities were actually not aware whether this information exchange between their competitor is a problematic under competition law or not. So they were simply ignorance of law, which you can actually, if you want to say in one words, there was a complete ignorance of law about this particular subject, right? For example, if you look at abuse of dominance, when the CCI imposed say penalty running into say 600 crore on DLF, when DLF was abusing a dominant position in high-end residential apartment in Gurgaon, because unilaterally they increased the height of the building, instead of having say 8 floors, they increased it to 16. So the apartment owners was having a less space for XYZ things. If you don't pay to builder on time your EMI, you are going to be punished in terms of 18% interest. But if the builder is not finishing your project within time, the cost is very less. So when the commission is imposing these kind of fines, so most of the time what you are going to find is, in their defense, these wrongdoers, they say we were actually not aware what this competition law is all about. So the job of the commission is to basically provide, to disseminate the knowledge about this subject. And the ignorance could be such, the commission also find a query that what exactly competition is all about, whether it is controlling or regulating competitive exam in this country. One can say whether it's a regulating all those NEET or say CLAT or judiciary exam or whatever exam it is. So it has anything to do with the competition which we know otherwise? The answer is no. Competition law is basically, you need to look at from economic perspective. You need to look into, there should be a market in which there are large number of producers, there is a large number of distributors, there is a large number of consumer. So there should be competition in the market. So how to educate different stakeholders, right? For that, you have a provision of this competition advocacy, in which the commission is trying to educate as many people as possible. I can simply say this seminar itself is a part of competition advocacy, that the people who are actually not aware about this subject should have some idea that if there are 4 competitors and they are discussing about the price, it's a problem under competition law and you can be caught under section 3 of the Competition Act. If you are a dominant, if you are trying to abuse your dominant position, it's a problem under competition law and the penalty could be 10% of your turnover. So it's a basically, competition advocacy itself is a tool by which the commission is coming to the stakeholders and trying to say, boss, this is a law which you need to follow. If you don't follow, then you may be in a mess. So this is what competition advocacy is all about. Any question?
Hello.
Yes.
Sir, am I audible?
Yes, yes, you're audible.
Sir, we are getting some issues from the connectivity of the students, but I got some questions on their behalf. So I
Okay.
would like to ask you on their behalf.
Okay. Okay.
Sir, as we know that Reliance Jio has got a big marketplace sharehold in today's time. So how can it be called anti-competitive? What Reliance Jio did, what should be considered as according to the law or not?
You see, it's like this. Just I understood your point. When we say competition law is something that regulator is trying to promote competition in the market. Okay. It is the job of the regulator to punish those entities like provision is to promote the competition, right? So I just told you, when we say anti-competitive agreement, what exactly anti-competitive agreement? Anti-competitive agreement is, we have studied in contract, we may have an agreement, but we can't have an agreement in which me and you both as a competitor, me and you as a different producer try to coordinate our prices. So if you try to coordinate the prices, or if you try to allocate the market, or if you try to indulge into say bid rigging, so the job of the commission is to prevent those anti-competitive stuff in the market. So what exactly we are doing is, anything which is harming competition, right? Right? Anything which is kind of controlling the free access in the market. So we try to prevent those practices. So that's why the provision is named as the anti-competitive. And if you look at the act, the heading is the prohibition of anti-competitive agreements. So if you have an agreement which is promoting competition in the market, right? Your competitor is having some joint venture which is increasing efficiency in the market or which is complementary in nature. So those practices are indeed being promoted by the commission. The only thing is you should not do something which should restrict the market. I can just give you an example. For example, you have a say Vodafone, you have a say Airtel, you have a say Jio. Let's assume a situation, these four players, and you also have a say BSNL. Let's assume a situation, these four competitors, their CEO or the MD is sitting in one conference and they say, we don't want this price war. Let's do one thing, we should charge 10 rupee per minute. Let's assume. Think about this, that four competitors, four telecom players, so when they say instead of charging say 30 paisa per minute, price to rupee 10. Whether this should be allowed?
That's what I'm asking. Is there any emergency in the home? So you are just talking about.
Not that, what they're trying to do is they're trying to restrict all kind of activities, all kind of say conduct.
You want to switch on your camera right now?
For example, in the contract law, you need to have a say offer, acceptance,
Switch on your camera.
these things. The definition of these agreements under competition law is very, very
Emergency
fine, can happen without any XYZ consideration. I just told you, for example, telecom player say hereby we are going to charge rupee 10 for each call. We all use Uber and Ola and Mero. These three or four different cab aggregator from tomorrow, instead of charging say 10 rupee per kilometer, per kilometer. So where will be the consumer interest in that? So anything restrict the market. Those practices needs to be prevented. These practices needs to be prohibited and punished, right? So this is what the competition is all about.
So then, so linking to the same question that everyone wants to grab the market share. But then due to competition law, this becomes a little impossible for a businessman or any new person who wants to come into this field. For a businessman, they have the vision of having a monopoly in the market as everyone feels of and dreams of. But then competition law restricts it. So how is it illegal?
See, if you actually competition law is not restricting. Competition law is basically trying to say that promote, you should promote your business, you should capture the market by using innovation, by reducing the prices, by providing the best services of goods or services at the cheapest rate. So if you try to do this by way of innovation, right? By enhancing the productivity, by reducing the cost without any XYZ coordination with your competitor, that is what is allowed, right? So there is no prohibition that you should not grow. Even being a dominant is not a problem in competition law. Just keep in mind that you may have a market share of 90%, you may have a market share of 50%, or you may have a market share of say 70%. So being a big entity is not a problem. You see, anybody is a big in the industry because of certain inherent strength, right? It's not because that entity has become big only by indulging into anti-competitive stuff. The answer is no. Let's assume a situation, you take any industry, right? So for example, you have a Geo, right? Geo may have a say market share of 40%. It's not because that the Geo has indulged into predatory pricing, that's why they are dominant. They have a market share. Or in the aviation industry, the Indigo is having a market share of more than 50%. It's not because the Indigo has done the price fixing with competitor, or the Indigo has acquired small players in the market. Indigo market has increased because of the reason what they did a lot of innovation. They were very efficient in their running. They try to have their flights on time. They provide us tickets at a cheaper rate. They try to provide better services in their flight or say at the airport. So that's why the market share of the Indigo started from 0 and now it's at say 53. In the similar fashion, if say the market share of Air India has down say from 15 to say 10% now, it is not because of any competition or something. Because if you are not able to provide best services at the cheapest rate, the consumer, you are not going to have a patronage of your consumer, of your customer. So if you are flying say XYZ Airlines and every time it remain late or something, you would prefer not to fly. You will choose to have a competitor which is providing you the cheapest rate in ticket, which is providing you the best services. So the competition law is actually not restricting that you can't be a big. You can be even as say 90%. Say market capture, you can do it. The idea is you should do in a kind of, I would say, the ethical way. If you try to indulge into say cartelization, if you try to enter into say price fixing, if you try to do the bid rigging, if you try to indulge in any kind of anti-competitive stuff, only in that situation the competition regulator is coming to the rescue of the say consumers. So you can be big, you can have a market share of say, because market share in itself is an indication that that particular firm or entity is having a XYZ expertise in this area, right? I can just give you an example. That would be very kind of not very appropriate, but let's assume you may have a say 10 top lawyers say in Supreme Court, and they are charging say in lakh or say in crores, right? But they are not indulging into this say price fixing or something, right? People or the consumer is approaching them because they are providing XYZ or desirable services. Or let's take a situation of you may have a say five, or let's assume that you have a say Uber and you have a Ola and you have a Meru. We all of us is having a no connection with all these say cab aggregators. Why we prefer one and why we are not preferring another? It's a very simple that if you have to travel say from Rohini to Gurgaon, what you do is you look at the price of say Uber, you say it's a say 400 rupee, you immediately look into the Ola app, you find it's a say 300, or you may have a Meru which is say maybe having a say 200. You said whosoever is providing me the cheapest cab, I'm going to travel by that, right? So the market share is actually being acquired or it's being grabbed by these entity by conducting themselves in a particular manner. So 20 years ago, these entity were not in existence. Just take another example. You may have a Swiggy, you may have a Zomato, you may have a some XYZ different, say, this food kind of service provider. So what you do, you are interested in buying something, you are trying to locate that whosoever is providing you the goods or services at the most competitive price, right? Imagine a situation that you have a say all these Swiggy or Zomato or whatever XYZ entity is, they are reaching to a decision that henceforth we are going to charge rupees 50 for every delivery. So if they fix the prices for their services, then there will be no incentive to innovate. Let's assume a situation coming back to the aviation industry. Let's assume from Delhi to Mumbai, all these flight is having the same rate. Let's assume, say 10,000. They come and they decide that henceforth from tomorrow onwards, we are going to have a say 10,000 rupee flight from Delhi to Mumbai, even if it is Indigo or even if it is Air India or Vistara or XYZ entity. What would be the response? And why it is a problematic? Because the moment you are fixing the prices among different competitors, there would be no incentive to innovate. There won't be any incentive to provide better services, right? So what exactly you are doing is these entities will not be bothered about if the flight is going on time, or they're providing in flight say XYZ snacks, or whatever their crew member behavior towards their say passenger or something. So unless they feel the say some kind of competitive environment, you actually cannot excel. Let's assume a situation that in your class there are say 50 students, and now the college says that even if you read, even if you don't read, even if you study, you don't study, everybody is going to get a say 50% mark in the exam. Then people who are not studying, or even if they are studying 2 hours a day, they will say, what is the point of studying if we are going to get a 50 marks in the exam? So where is the incentive to innovate? Where is the incentive to perform better? Because there is no competition in the market, right? So the idea of this entire competition law is anywhere. And Indian competition law is actually what we have done is we have borrowed say 60% from the US and the 40-50% from the EU. By and large, the competition law worldwide remain the same. 80% stuff remain the same. You do plus minus here and there. So the idea is you try to promote competition in the market, nothing else. Just take an example that in an institution, supposing you have a just one photostat shop. Just take a situation. So you are paying XYZ price. What would happen if there are enough competition to that shop, this Xerox shop, if you have a 4 or 5 different Xerox shop in your say institution or something, or it could be about canteen, right? It could be about anything where we are getting XYZ services. The intuition says if you are going to have a more competition, it's going to be have a very cutthroat competition in the market. This is what competition was trying to promote, and anything which is trying to restrict that competition, that is something which needs to be investigated and that needs to be punished. For example, you may have realized during say New Year time, you find the flight ticket to say Goa remain very expensive. Why it is so? Because there is a lot of demand and there is the same set of supply. So the price is artificially going up. So if it is going up and down, if the different airlines is having their own unilateral pricing strategy, that is fine. But if all these competitors are joining hand together and then they try to restrict the market by fixing the price or something, so this is something which needs to be prevented. So that's the precise idea about this competition laws. You can come to the next question. Sorry, I can't hear you.
Hello, sir. Am I audible now?
Yes, yes.
Yes, sir. Sir, before proceeding to the next question, I would seek your permission to announce something.
Okay.
I would request all the students as presented here as audience to please switch on their cameras, and you may ask questions from sir.
Okay.
The students are please requested to ask questions and switch on your cameras. So by the time we get other questions, I would also like to ask you one question from my end.
Okay.
Sir, can we say that competition law gives the big industries in the society a chance to exploit resources, as in the case, again, if we take Reliance Jio, then can't we say that because of their hunger of being the number one in this society today, they have exploited resources at the utmost level?
You see, there is no straight answer to it, and I can explain you why. Prior to 1996, you just have BSNL and the MTNL, right? So these were the government entity in the telecom industry. So at that time, even if you have to get a phone connection, you need to wait for 1 year or 2 years to get that phone connection. Now, post 1996, you have the Telecom Act and you have all those private players coming into the market. Now, the Geo was the major disruption. And why it was a disruption, let me just explain. Prior to Geo, you have a say Vodafone, you have a say Airtel, and you have a say this uh, Airtel, and then you have an Idea 3-4 player, GSM player. So they were the established player in the market. Everybody was having a market share of say 30%, 40%, or 50%. Then suddenly you have Jio. And what was the most attractive thing about Jio? They were providing virtually everything for free in order to attract the customer, right? Now, if you ask me why the Jio was indulging into that, and it's a no secret why they wanted to do it, because they wanted to acquire the market power. They started with a 0% market share, and the market is already divided into 3 and 4 and the 5 say players. So if you are a new player in the market, what you are going to do? Your strategy would be to have a patronage of more and more and more customers. So why you are going to do that? If I am using say Vodafone, or if I am using to Airtel, why I should switch to Jio? Unless Jio is providing me something good, which is not actually being provided by say Vodafone or the Airtel. So Jio started with just zero pricing. That you take my phone, I'm not going to charge you for 3 months or 6 months or whatever, 1 or year or 2 year, I'm going to provide you 10 GB data or whatever. So their deal was better as compared to the existing player, right? So they entered into this market. Now in competition law, you basically have two schools of thought. There are a couple of schools, but there are two major schools of thought. One is Chicago school and another is the Harvard school. These are the schools of thought, nothing to do with the Harvard Law School or say Harvard Business School, but the school of thought which is being propounded by a couple of professors or academicians at these two, at the Chicago and at the Harvard. Chicago School of Thought says if the Geo is providing everything for free, so what's harm in that? We as a consumer is getting that product or services at a very cheaper rate. I was paying 500 rupees to Vodafone and you were paying say 1000 rupees to Airtel. Now Jio is providing at the free of cost everything. So why as a consumer I should be bothered about what's going on in the competition? Even if the Jio is going to have a market share of say 90% or 70% and Vodafone is getting bankrupt, why as a consumer I should be concerned about? So the Chicago school says that the competition regulator as such should not be much worried about these, because at the end of the day consumer is getting benefited. We all get benefited at the cheap rate of the Jio. But then there is a catch. If you ask any entity why they are in the market, everybody is trying to maximize their profit. So Jio is not in the industry for charity for sure. They are in a business, and in the long run or say in the short run, they will try to leverage that market. So what they will do is first they come out with all those free offers, right? In order to attract existing customer of say established player, say Vodafone or Airtel or the Idea. So those customers switch from these existing player to they started joining Jio. Now then you will find when you have a say enough or say 10% or 15% or the 20% market share, you should ask, and we all should ask, the offer which Jio was offering way 5 years back, whether they are continuing with those free stuff now. The answer is no. So if you examine from competition perspective, it was a very interesting that when the Jio had this phenomena of providing everything for at 0 rupee, so Vodafone, Airtel, and third one, whoever was, they made a complaint to the CCI. And they said, look, by providing everything for free, Jio is indulging into predatory pricing. So there is an abuse of dominance by Jio. For abuse of dominance, as I told you, you need to be a dominant, and then you try to abuse your dominant position, either indulging into exploitative or you indulge into exclusionary practice. So the complaint which was made by these existing player against Jio was, look, Jio is having a very deep pocket because its promoter is having a business elsewhere in so many different industry. So they can afford to provide their services at 0 cost. But actually it's not a 0, it's a predatory pricing, because their tendency is to, because of they are the deep pocket. So what they want, because if you provide for free and these services are actually not free, so the Vodafone or the Airtel cannot match with the Jio in terms of deep pocket. So these people complained to the CCI saying the Jio is indulging into predatory pricing and they are trying to drive we player out of the market. And once we are out of the market, the Jio is going to increase the prices and they are going to exploit the consumer. So that was the complaint. So one complaint was these player against Jio. The counter complaint was also filed by Jio. Jio said, actually, this telecom industry is a kind of cartelization by Airtel and say Vodafone and the Idea and all these players. Because these people in last 10-15 years, what they are doing is the prices is not getting reduced. And the consumer are actually forced to pay more prices for their absurd services. They are not providing good services. They are not bothered about the customer. They are not bothered about the consumer. And we has thought to provide these things at the cheapest rate. And in order to get the customer, I'm indulging into all these promotional kind of or say discount or say zero pricing or all these things. What happened? The commission closed the matter against Jio. Though there is a lot of criticism that why Jio was not investigated for abuse of dominance. Commission's reasoning was that look, when the Jio started, it was having a zero market share. So for abuse of dominance, first thing which you need to figure out under Competition Act, under Section 4 of the Competition Act, the entity, first you need to define a market. So the market you are going to say the telecom industry in India, right? In the telecom industry, you need to be dominant. Now, how you are going to be dominant if you are having a 0% market share? So if for a beginner like Jio, you don't have a market share. Rather, these existing players, say Vodafone or the Airtel or the Idea, they were having a market share of 30%, 20% or 40%. So the Jio argued, which eventually agreed by the commission, that the Jio is a new player. If it is a new player, it doesn't have a market share. So Jio actually cannot dictate its terms on the market, on the consumer. And other competitors are already there in the market for the 20-30 years. So there is no question of examining abuse because Jio is not dominant. And if you look at the data of that point of time, 2015-16, when this Jio phenomena happened, at that time Jio was having having a small percentage of the customers. So if you are the small player, you may have a deep pocket in petrochemicals or XYZ industry of Reliance. So that's not the issue. Commission said it's a new telecom player, it's a trying to enter into the market. And perhaps though the commission has not said in so many express terms, but I think their idea was at the end of the day, the consumers are getting benefited. We all are getting, say, data at the cheaper rate. So what's harm in that? So Chicago School actually proposed that idea that if the consumer is getting benefited, there should be free market. In future, if Jio become big, Jio become a dominant, and it tried to exploit the market by increasing the prices. At that situation, what will happen is Chicago School argues that the other competitors who were driven out of the market, they will eventually enter the market and the price is going to be stabilized. So let's assume a situation if we are using Jio and if the tariff of Jio is increasing say 100 or 200 or 300, we as a rational human being, we will try to switch because there is no loyalty concept as such. If we are getting the same stuff what Jio is providing to us, tomorrow if the Jio become expensive and if the same services is providing at the cheaper rate by say Airtel or say Vodafone, we will switch over to that. We will simply port that number. We will say why unnecessary I should go to the Jio. So the thinking of the Chicago School of Thought is as long as consumer is getting benefited, the competition authorities should have a hands-off approach. Let the market should take care of its own stuff. If one competitor is trying to capture, trying to exploit, the consumer should have a choice to go to any of the alternate. So at that time, what the commission did, the commission closed the matter against Jio. But in a surprising way, what the commission did, commission ordered for investigation of the allegation of cartelization against all these three existing players, in which the Jio was complainant. Because the Jio argument was that these existing player, these people has formed a cartel. These existing player is having a club, Cellular Operator Association of India. So they have formed a association. And what they are doing is they are trying to fix the prices or they are allocating the market or they are indulging into all these things. So the entire every in the telecom industry, according to Jio, was these existing player. So the commission launched that investigation. Now it's altogether different story. These established player, because they were kind of having a victim card, and then investigation was launched against them. So they moved to the Bombay High Court. The Bombay High Court actually said, no, it's basically something which needs to be investigated by Telecom Regulatory Authority of India, TRAI. And the specialized regulator is TDSAT, Telecom Dispute Settlement Appellate Tribunal. So because in the telecom industry, you already have a special regulator, then the CCI should have some kind of hands-off approach. Because the allegation of cartelization or the allegation of all these things can also be looked into by another regulator, another body, right? So CCI should not have a kind of hands-on approach on these issues. Matter eventually came to the Supreme Court, and if you read the Supreme Court decision, you will find there is not much clarity to me, because at the one time Supreme Court has recognized the fact that as far as issue of cartelization is concerned, issue of price fixing is concerned, issue of abuse of dominance is concerned, the CCI is the expert body. The CCI must investigate and the CCI must punish whosoever is trying to capture the market. At the same time, they also said that for the telecom industry, you have a sectoral regulator, TRAI, and you have a TDSAT, and then you have an entire Telecom Act. So for those specialized regulator, CCI should have some kinds of hands-up approach. So that's again debatable. But then at the end of the day, what these regulators are trying to do, because these regulators are supposed to enforce in order to promote, in order to implement whatever their parent statute is talking about, right? So a body which has been created under the Competition Act, they will try to promote and ensure, they will always talk about competition. A body which has been mandated for the telecom law, for the telecom pricing or licensing or XYZ, so the telecom regulator is going to speak in their own language. We as a consumer should always be some kind of vigilant, that we should always try to figure out, as a student of competition law, that what is going to be the effect of the competition, what is the effect of the competition prior to that particular incident or phenomena, and what is the position post that phenomena. So in the geo issue, we all were quite happy 5 years ago that everything is free, but now we are realizing that eventually the geo is also charging XYZ prices. So we are back to kind of square one. So now you have a 3 player, you have a one more player, then out of these 4 players, you are finding one firm is getting, say, kind of defunct, or it's going to be bankrupt or something. So you always find 3, 4, 5, more entity will come, the existing player will be vanished, and this is precisely the competition. As a competition regulator, they are not supposed to protect the competitor. They are supposed to protect, there should be competitiveness in the market. Whosoever is the player, that's immaterial. You can come to the next question.
Thank you very much, sir. Our two vice presidents, please go on with your questions.
There is a lot of
Good afternoon. My question is the policy of competition in the mergers and acquisition taking place in digital space.
Harpreet, I would request you to please turn on your camera and please be a little louder.
Sir, my question is, what is the policy of competition law in the merger and acquisition taking place in digital space?
Okay, that's the very good question, and it's like this. If you look at section 5 and 6, what has been the mandate is basically like this. In a merger and acquisition, you are going to have a 2 entity, right? So one entity is called acquirer, and there will be another entity which is going to be the target. So if you look at the act, when acquirer and the target, and there is a threshold. Threshold is like this. Supposing a company A is acquiring company B, and you say in the digital economy or whatever XYZ entity it is. So if the target entity is above a threshold, right, then you need to take a permission from the commission. At the moment, it's a 500 crore. 500 crore meaning thereby, supposing a company A, which is a worth of say 200 crore, and that company is acquiring an entity which is say 20 crore. So you don't have to go to the commission, you don't have to take any approval. because neither the acquirer nor the target is crossing that minimum threshold, right? So entity say which is in Gurgaon, which is having a turnover say 100 CR and is acquiring a company which is having a say 1 crore or 2 crore or 3 crore. In that situation, you don't have to notify to the commission, you don't have to take any permission from the CCI. But if the acquirer or the target is crossing a particular threshold, right? Let's assume a situation that you have an established player say in IT industry. So let's assume you have an Infosys or you have a say Wipro, and you also have a TCS, and they are the competitor in say in the IT industry, right? Or let's take a situation that you have a Ambuja Cement and you have a Sri Cement. Both is having a say 10, 20 different kind of say market share. These acquirer and the target both are crossing a particular threshold. The target is also more than 500 CR. The acquirer is also more than say 1000 CR. So there is a benchmark given under the act. If you are crossing that particular threshold, so section 5 and section 6 is actually telling you, is guiding you. If you are crossing this particular threshold, you need to notify your proposed combination. The term which they have used under the act and the regulation is a combination, and the combination could be either merger or it could be acquisition or it could be amalgamation, whatever kind of corporate structuring you can think about, everything is covered. So if you are crossing that particular threshold, you need to notify it to the CCI, right? Which is a practice almost worldwide. So if you are say in the US, acquirer and the target is say in the US, then you notify to the Federal Trade Commission, FTC. If you are say in Europe, you need to notify to the European Commission. They have the Directorate General of Competition. If you are in India, you need to notify to the CCI. If you are in Australia, you need to notify to the ACCC. They have the Australian Consumer and the Competition Commission. So all these jurisdictions are local in nature, meaning thereby, if that proposed transaction is having a presence in different jurisdiction, so you need to take permissions in all these jurisdictions, right? So supposing a American firm is acquiring a Chinese firm, let's take a situation, and these acquirer and the target doesn't have any presence in India. Let's assume a hypothetical situation. So you don't have to come to the CCI because you don't have any Indian access. Acquirer and the target, these two entities are foreign. They neither have any assets in India nor they have any turnover in India. So you don't notify to the commission. Now let's assume you are crossing those thresholds in India. Either acquirer or the target is having a presence in this country by way of say assets or the turnover. So then you approach the commission. There is a 3 different forms. You have a form 1, form 2 and form 3. Form 1 is actually a procedure which you are using if there is no competition concern. It could be like this. Supposing A is in say IT industry, the target is say in financial market, and these two companies business is altogether different. Supposing you are the manufacturer of say truck, and you are going to buy 5% stuff say in say Tata Tea, right? So the post transaction, the competition is actually not getting affected because these two entities are operating in a different sphere. So it will be form 1, which will be very simple because on the face of it, it doesn't going to have a say competition concern. So it will be very simple form.
Sir,
Form
yes,
2
sir, in which we can say Google is in a dominant position. Sir, doesn't it abuse its dominant position in the competition market?
It is.
So what?
You can just elaborate your question that Google is facing multiple investigations. So I'm just trying to figure out.
So what can competition law in this regard can do?
Can you just rephrase your question that which practice of Google you are trying to?
Sir, Google in the internet market, sir. He's a web page. He's abusing his dominant position. Can't the competition law control that dominant position abused by the Google?
Actually, as a matter of fact, Google is being investigated almost in all major jurisdictions. And what you are saying, I can just give you a few illustration. Supposing if you go to the Google, right, and if you type, say, travel from Delhi to Mumbai, right? So those company which are paying to Google, say Make My Trip or Evibo or XYZ, those which are paying to Google, their result would be in top 5 or top 10, right? So we as a consumer, what we do, we type something on Google, and whatever is the first or second or the third search result, we by intuition click on that. So Google is supposed to be an online platform, right? They should not be in a position to differentiate between X or Y or Z. But then there is a huge issue of algorithm, right? That why it is that if you type, say, Google Travel, the first is, which is coming into C is Make My Trip or X or Y or Z, whosoever is paying to Google for their advertisement or something. So the Google has been under investigation in Europe by the European Commission since 2010. Google has been under investigation by the CCI. Google has been under investigation now also before the DOJ and the FTC in the US. Google is under investigation in almost all market, I can say. Only difference is that how much these competition regulator has been in a position to punish it. The problem which you just cited is just one of the problem with the Google. Google is a dominant in online search. There is no doubt about it. Worldwide, somewhere it's a 97%, somewhere it's a 92%, somewhere it's even 99%. So by default, in all our laptop and the computer, you will find Google as a default, say, browser. Now, come to the next. In European Commission, they have been punished thrice. In India, they have punished once. If you look at the US market, Google has not been punished yet. So in Europe, for the same kind of allegation, for the same kind of the preferential treatment to their own XYZ stuff, or say online search, so you will also find few competition regulators may have a very hands-on approach. Few regulator may have a hands-off approach. Few regulator may be somewhere in between. So if you ask why Google has been punished thrice by the European Commission and just once by the Indian Competition Commission, and why it has not yet been punished by the US. If you ask somebody, some US scholar, one answer which he will give you, why in all these antitrust matters, all American big giants are being punished by the European Commission and not punished by the, say, American authority. So their kind of cynical answer would be, you see, these Europeans, they are not in a position, they have not produced a competitor of Google in the entire Europe. So the be it a Google or be it a Facebook or be it Amazon or be it say Twitter, XYZ, all these are the American giants. So these American giants has not been punished by the American competition authorities. And all these entities which I have just mentioned has been punished by the European Commission. Right? Few of them has also been punished by the Indian competition authorities. Allegation remain by and large remain the same, be it the US or be it EU and be it India or be it Japan. But different competition authorities has adopted their own different mechanism of investigating. If you look at the Indian Competition Act, you have a provision in which somebody is making complaint to the commission. The commission is prima facie being satisfied if there is a case against dominant entity or not. Matter is being investigated. Investigation, if you look at the act and if you look at the Supreme Court decision in SAIL, it says the investigation should be over in 60 days. But practically no investigation has happened within 60 days. It takes years and years and the years. And after years of investigation, you are going to have a, say, DG report, Director General report, saying indeed there is a contravention of abuse of dominance or something. So now once you have that DG report, then the commission passes final order. So the matter is finally decided by the commission after a few years. Then you have a provision for appeal to going to the tribunal or going to the High Court and the Supreme Court. So if you look at the process, this process, whether the Google has abused a dominant position in XYZ, you find that the first punishment which they had in Europe in way back 2012 and 13, India punished somewhere in 2018. US has not been in a position to punish Google so far. Now in terms of penalty, If you look at the penalty which has been imposed by the European Commission on these kind of abuse of dominance practices by Google, it's running into several thousand crores. In India, we have a few hundred crores. In the US, it has not been so far. But then US is having a antitrust regime of 125-year-old. But they are not in a position to. Now, if you look at in the last 3 years, now in the US, both Democrats and the Republican, there is a bipartisan support that these tech giants, be it a Google, be it a Facebook, be it a say Alphabet or XYZ, these 5, 6 tech giants, all these entities are now actually being investigated in the US either by the Department of Justice or the FTC in the last 2 years. So this movement has started that these tech giants has become so big because it's a threatening my democracy, it's a threatening Trump, or it's a threatening X or Y or Z. So these entity has become too big. So something needs to be done. And the old traditional approach of competition law, which we discussed, that anti-competitive stuff or abuse of dominance or the merger control, these old regime, these old provision statute has not been in a position to control or curb or regulate these tech giants. So now they have also woken up, they are investigating. We don't know whether they are going to reach somewhere or not. But the Europeans have been far ahead as compared to the US in terms of antitrust enforcement. They are punishing Google for the last almost 10 years. The few matters has gone to the European Court of First Instance in Luxembourg. Few matters has even reached to the European Court of Justice, the highest court within the European Union. So they are kind of ahead. If you ask me where we stand somewhere in middle. Because we also as a country fear that if you are going to punish Google, so whether India as a IT hub or say global hub or something, or digital India, whatever, all those political consideration could be one. So all these competition authorities worldwide, they try to locate from competitional perspective for sure, but it is also to do a lot of with the thinking in terms of the outlook of the government, outlook of the regulator. There are so many different considerations. Actually, it doesn't operate in that vacuum, that you just follow the spirit of law and you try to enforce it.
Thank you.
We can come to the next question.
Okay. Thank you very much, sir. Thank you very much for clearing all our doubts. I think all the students have got the answers for their questions.
Okay.
So, although this question round may go long, but I think that there are some time restrictions as well. So, I must conclude this session here. Now, I would welcome our Honorable Head of Department, Mr. Vijay Kumar Yadav, sir, to extend a vote of thanks.
Hello. Hello. Hello, ma'am. Can you hear me?
Yes, sir. We can hear.
Yes, sir.
Let me give vote of thanks to our chief guest, Asif. You are finishing the program without the vote of thanks. It is not suitable for everyone. So our respected chief guest, Mr. Avinash Sharma sir, my dear teacher and my dear student, those who are joined in the program. It's immense pleasure for me to deliver the vote of thanks to all of you. As Avinash sir has discussed all the story of Geo Mobile Network, really it's very, very interesting in the field of marketing. And these people have established a milestone in the way of marketing. In marketing, we always know this thing that as bigger as you take the risk, you will get the profit on the same amount. So this Geo Mobile company has done the same thing. They have started Geo Network and then they have started free mobile phone. So everybody has get addicted. जैसे हम कोई नशा करते हैं, so we have got this addiction with this mobile phone and network, and everybody in the village and in so many remote areas, they are all connected. And after getting acquaintance with the mobile connections, now Jio has started taking charges and policies also. So now we are all in the trap of Jio Mobile company. So in this way, Jio has finished other competitors in the market like Vodafone is there, Airtel is there. So these companies are now suffering. Now Jio is going in number one in all this. So as Avinash sir has discussed all the things in very nice way. And so many students have asked very nice question, interesting question with sir. And sir has answered all the questions very brilliantly and interestingly. So I have been listening all the question answers with student and with sir. So everything was very good. I really enjoyed. So I'd like to thank Mr. Avinash Sharma who has managed his valuable time and given this time to our students. So no doubt it's a very motivational program for all the children and as well as for students also. So we'll be looking a long association with Mr. Sharma and coming webinar also we would be calling sir to get this types of motivational speech. So at the same time, I would like to thank all my teachers, my dear students, and especially I would like to give thanks to all students, those who have given this passion, listening this habit here. So more than 65 students were joining in the session. Really, it was very interesting and very good. So once again, I would like to thanks to all of you, especially for Avinash sir, for Parul ma'am, and this anchor, little anchor, Ashish, Dral, and all the students. Thank you very much to all of you.
Thank
Thank
you
you.
very much, sir.
Thank you very much,
I
sir.
thank our honorable speaker, Mr. Avinash Sharma, once again for sparing his precious time. Hope your words of value are a life changer for many and motivation for everyone. Thank you very much, sir.
Thank
Thank
you.
you.
Thank
Thank you
you
very
so